Good morning, Jack.
Morning, Bob.
This morning, we have something important to talk about, and that was the Supreme Court argument yesterday in the Birthright citizenship case. You've just posted an extended analysis of what was exceptional about the case, what people really should take away from it as central. And so let's start with that. Why don't you describe what you say in that piece, and then we'll take it from there.
Okay, I should probably start with just giving a quick background on what the case was about. This was a case involving the Trump administration's executive order on birthright citizenship, and which has been very controversial. But the case before the court, or at least the argument before the court, wasn't mostly about birthright citizenship. It was rather about universal injunctions because many federal district courts and lower courts have enjoined the government on a universal basis from enforcing its birthright citizenship order. What does that mean? It means that plaintiffs bring a lawsuit and seek an injunction. And a universal injunction is an injunction that applies not just to the parties to the case, but applies to non-parties as well. Um, and so basically what's happened is that district courts around the country have shut down the Trump executive order on birthright citizenship. This has been a controversial issue for many administrations, several administrations, the Biden administration, the first Trump administration, I believe the Obama administration, I'm not sure, argued that universal injunctions were unlawful, that federal courts were limited to issuing injunctions against parties. So this was an oral argument primarily on that issue. It's a huge issue with implications far beyond this case. The government, has a powerful argument that there's a problem with the universal injunction since the traditional rule is that injunctions should only apply to parties, and also there's some problems with form shopping and asymmetrical burdens by the government and the like. So the government has a strong technical legal argument against universal injunctions. In this case, what I talked about in discussing the oral argument was the most extraordinary thing in the oral argument to me was that the Solicitor General went out of his way over and over again to concede judicial supremacy to the Supreme Court. And let me explain why that's unusual, and then we can talk about it. So, um, if if universal injunctions are invalid, as the government argues, that would suggest that even the Supreme Court can't issue a universal injunction, i.e., cannot enjoin a program that has an impact nationwide. And that would be a problem because it would mean that there would be no court that could stop a government from rampant illegality. And so Sauer, both in his application and in his oral argument, tried to preempt that by acknowledging that a Supreme Court precedent, that once the Supreme Court decides a case, that's that. And that precedent will be binding on the government everywhere and with regard to everyone. And that argument was absolutely key to, I think, to getting the court to agree with the Trump administration position, if it does, and I think it will, because it does give the court a way to stop widespread illegality. And I'll note finally, and then I'll turn it over to you, that this is an extraordinary acknowledgement by Sauer, not just because um, conservative administrations have always kind of hedged on whether they would, not just conservative, but usually conservative administrations have always hedged on whether they would abide by a Supreme Court precedent as opposed to a judgment. But it also, of course, comes against the background of the Trump administration threatening courts, threatening to or insinuating that it wouldn't comply with court judgments, people worrying about that. In the face of all that, this was an extraordinary set of concessions by Sauer.
So let's expand a little bit on the extraordinary nature of the concession. Explain to people who might ask the following question what they may be missing. The question they may ask is, well, when the Supreme Court decides a case, it's deciding the law of the land. What's exceptional about conceding that it is the law of the land and that, as you say, it applies everywhere and to everyone? Many people, just as a common sense matter, would say, well, of course that's the case. What could he have said that was different?
So, in a common sense manner, that is right. That is the way that the system basically operates. But there has always been a question. There's a debate about whether the Supreme Court whether it's just going back to Marbury versus Madison, whether it just decides the case before it and it derives its powers of decision under Article 3 and the judicial power from deciding and resolving a concrete dispute between parties, and whether it is doing more than that and declaring law for everyone. And it is true that the law declaration power has been generally assumed to be the right way of understanding what the Supreme Court does, especially in modern times. But it's also true that it's never quite been conceded in a Supreme Court decision, as best I can tell. Cooper versus Aaron, of course, made the point in the federalism context about Supreme Court decisions being the supreme law of the land, but that was in the context of the federal government vis-a-vis the state government. And while the commonplace understanding, the ordinary person's understanding has been the understanding as it's operated in the government as well, it's never been acknowledged to, to my knowledge to this extent. And especially coming from this administration, it's quite extraordinary.
And do you think, particularly because of recent circumstances in this administration, and we've written about that, their disregard of the law, I think it's fair to say, or seeming disregard of the law, the defiance of courts, the threat that perhaps they would defy court orders, that this was a point that we're really probing for. You had predicted that they were going to be looking for either this concession or the refusal to give that concession. Is that a fair way of saying what transpired?
I think so. In my piece, I described exchanges with 5 different justices in which this point came up, and in which, and especially Justice Barrett at the end, but not just her, where this point came up, and the justices were probing. As I say, this point was acknowledged in the application in a sentence by the Solicitor General. Justice Kavanaugh read that sentence and said, "I just want to make sure you agree with this." Sauer said yes. Justice Barrett pushed him on it. He said yes. Then she said, "I just want to make sure you're not hedging on this point. You're going to abide by Supreme Court precedents." And he said yes. It came up in other contexts. So yes, look, this was the first time that the Justice Department has appeared before the Supreme Court that in a context where the Supreme Court could in effect question what's been going on with regard to the executive branch's behavior in court. And these are not the types of questions that the court would have sought assurance on in other administrations, and they were clearly seeking assurance here.
Let me ask you a question here about the courses available to him as an advocate. Let's assume that he was under pressure from the president or others, or just on his own account, not to give that assurance, but also not to provoke the court. Can you imagine what the alternative would have been? How could he have fielded that question without creating, for want of a better term, an uproar?
I don't see how he could have fielded the question otherwise. I think that if there were any way for them to win this case and to win on universal injunctions and to, frankly, to have credibility before the court going forward, if there were any way to do it other than this, they would have done it. And the fact that they acknowledge the point in the application shows that they've been thinking about this and they understand the point. And then the fact that he came prepared to concede the point. And let me just say, Sauer was on pins and needles, and I thought went overboard in insisting on the legality of the Birthright Citizenship Executive Order. The justices were asking him hypothetical questions, and I just thought he was excessive in not giving on that point, as if there were another audience he was responding to almost, and I'm sure there was. But on the I don't see how he could have done otherwise than to concede this point about judicial supremacy and effectively about abiding by the court's precedents, and hope to have won this case, or frankly, to have much chance of success going forward, because what's the point of the exercise otherwise?
So you anticipate, and I think you say this in your piece, the court will take this to the bank, that we'll see this reflected in the court's opinion in some way. How do you imagine that's going to go?
Of course, now, no, this is speculation upon speculation. We don't know how the court's going to rule, and we don't know who's going to write the opinion, and we don't know what the opinion is going to look like. But just speaking in general, it seems foreseeable and this is exactly what happened in Trump versus United States, for example, that the court will take these extraordinary, favorable, explicit concessions and make them kind of the foundation for its opinion. I mean, there are 5 justices who have already more or less said universal injunctions are a problem. Justice Kagan even said that in an out of court statement. So it's not going to be a surprise at all if the court cuts back on universal injunctions. The question is how the court writes the opinion. And in writing the opinion, I don't know obviously, but I expect that the court will take advantage of and quote and emphasize these concessions that the government will comply by the Supreme Court's precedents when it decides a case against the government, against government illegality. Because without that concession, without that point, then as Justice Kagan kept asking, how are we going to stop illegal government behavior? How can the courts do so? It's really an extraordinary moment because this idea that the court's decisions will be abided by generally beyond the judgment has been kind of the glue that makes judicial review work for a long time. And I might be missing something obvious, but I can't recall a circumstance where this explicitly front and center in a case, at least not in a while. So I do expect the court to use that logic in its opinion, assuming, as I'm assuming, that it does in some sense grant the government's request to attenuate universal injunctions.
Let me ask a real quick question about universal injunctions, and then we'll go to the broader point again. Do you think the court is going to, and there was some argument about this yesterday, really shut these universal injunctions down, or attempt to give some guidance about the circumstances, presumably narrow circumstances in which they would be available?
This is very hard to predict. There are other ways to address the problem of broader relief. There are class actions. Sauer was talking about indivisible remedies. Sometimes a remedy against one person will have an impact on lots of people. And so there are other ways to achieve the ends of universal injunctions that are more consistent with law and process as the government sees it, and as I tend to agree. But it's very hard to know what the court will say about the validity of universal injunctions, whether they will go all the way and say, you just can't do these things, that basically an injunction is limited to a party, end of story, or whether it will say that's generally the rule, but there are some exceptions in equity and draw on some historical analogies. I just can't predict that. I do predict that the court will narrow, if not eliminate universal injunctions, while at the same time relying on this concession about abiding by Supreme Court precedent.
So let's talk about the effective precedent. Of course, for the precedent to be generated, the court has to rule. And that could take some time. And this timing question, that is to say, the period of time before the court actually does establish the law of the land, did come up in the argument. And can you talk a little bit about the problem there? What is the fundamental problem of timing
Yeah.
if, in fact, we have to wait for the Supreme Court to declare?
Yeah. So this was a big topic in the case. So once you can see that, sure, the Supreme Court can basically resolve government illegality universally by one of its rulings, the question comes up, well, what happens in the 2 to 3 to 4 years that it takes a case to get from trial to the Supreme Court? And that was the normal process for most of our history. That the courts of appeals would work it out. There would be so-called percolation, where different courts could take different takes on this, and that the Supreme Court would then decide the matter at the end of the day, and then its decision would be binding on the government everywhere. The worry about and that is probably the way the system should work in general. That system works less well when the federal government, as it has been under the Trump administration to an extreme degree, but also under prior administrations, is being very aggressive on executive orders and really persistently pushing the envelope on presidential power in ways that the court often ends up saying is unlawful, and it's done that in Republican and Democrat administrations. Because then you face the possibility that the government could engage in illegal behavior for years with and then the court weighs in 4 years later, and then there's been 4 years, 3 or 4 years of illegal behavior. That, if there's no universal injunctions, the vast majority of the public will be subject to, because the injunctions that do take place below will be limited to the parties. So the problem of timing is exacerbated when there is a large degree of illegal government action. And here, of course, and that's why this is either a wonderful case or a terrible case, depending how you look at it, to raise this point. The executive order here is almost certainly illegal. I mean, it flies in the face of a Supreme Court precedent. There have been some originalist efforts to revive it, but the practice has been clear. The precedents are clear. So this timing problem is a problem. And this is why, let me just say one other issue that came up. An issue came up, well, what about the timing problem is alleviated, and this gets a little bit technical, but the timing problem is alleviated if at the Court of Appeals level, if something is blatantly illegal and the Court of Appeals can get to it fairly quickly and resolve the issue in the right way, then that tamps down on the problem of this kind of illegality for years, assuming that the Court of Appeals precedent is binding on the government. And on that, in the way that Sauer conceded it was in the Supreme Court, and on that point, Sauer hedged. He said the Justice Department, and he might be right about this, doesn't always acquiesce in circuit precedent. There are some occasions when it doesn't. So that was another wrinkle. But the basic problem with timing is if you don't have universal injunctions, then it can take years to stop obviously illegal actions.
Throughout the argument, there was some discussion about the extent to which the merits would have to be taken into consideration. I think the phrase was, do we have to peek at the merits? And let me ask you this question. On something like whether or not circuit court decisions would be observed throughout the entire circuit, the degree of weight that would be given to circuit court decisions, don't you think that Sauer's hedging was particularly problematic precisely because of the nature of the case here, that it involved a fundamental constitutional issue, a fundamental constitutional right, and that would have struck the justices particularly hard, that even if there were circumstances in which circuit court precedent was not observed throughout the circuit, here was a case where you would expect the government to concede that, well, maybe this would be different.
Yes, I mean, yes, I believe this is exactly right. I'll just say I was trying to make this point a little while ago, and I didn't make it clearly. Yes, this is an especially problematic case for this timing problem, and for the government to be saying we might not acquiesce in circuit precedent, precisely because not only is it an important constitutional right, but until January of this year, it was a well settled constitutional right, on which there is, in my view, pretty binding, although 150-year-old Supreme Court precedent. So what's at stake here is not just a novel constitutional right. It's an old and settled constitutional right, and one on which the court has weighed in, and one that has been long settled. And so this is a context where it seems especially problematic for it to take 4 years to resolve the issue. And this is what I meant by saying, and there are a lot of executive orders like this by the Trump administration, maybe not all quite as obviously unlawful as the Birthright Citizenship order, but this just raises the stakes quite a lot for the court to deny universal injunctions. And if I can make one more point, the Chief Justice said, well, is timing really a problem? Look what we did in the TikTok case. We decided that case in a month. And that's true. The Supreme Court can, if it wants to, grant cert before judgment, expedite the merits, have a quick briefing, and decide a case in 4 to 6 weeks if it wants to. It's done that a couple of times. It's had expedited review several times in the last few years. That's true, but it also kind of defeats the percolation point. I mean, the whole one point of getting rid of universal injunctions is that you want to allow time for cases to percolate below. And if there's going to be a need to expedite cases because of rampant illegality during the interim period, expedite cases to the Supreme Court, it's not clear how much is being accomplished in terms of ordinary decision-making and deliberation by eliminating universal injunctions.
I'm glad you mentioned percolation, because that struck me too. Sauer several times emphasized that he thought in the ordinary course, you want these issues to be considered by district courts around the country. In other words, you want the issue to percolate before it gets to the Supreme Court of the United States. And again, here it struck me, and tell me if I'm wrong, the context really matters. That as you point out, there doesn't seem to be much question that the executive order is illegal. And so the emphasis on percolation struck me, quite frankly, as cynical and
Yeah.
would come across to the court that way. Am I being overly critical?
No, I don't think so. I mean, look, the percolation point is a fine point and an important point with regard to a novel legal issue, a new statute, or maybe even someone who's claiming a new constitutional right and who's litigating that in the normal course. There, it's fruitful for the court to have the wisdom of different factual scenarios, different judges weighing in, learning over time. And in that context, it makes sense. And that principle might apply in the run of cases that are governed by universal injunctions, but this case is an especially bad one to make a percolation point. What he's basically saying is there's been 150 years of clear law. We've decided to defy it, and you, the court, should let this percolate for a while in the lower court so that we can basically act unlawfully for 4 years until you get around to deciding the case. It's a weak context to make a percolation point.
And he referred, by the way, in addition, as you say, to his overstressing from a strategic point of view. I also thought it was striking, overstressing the merits of the case, presumably because he had to address a certain audience, and it might have been an audience of one seated in the Oval Office. But either way, he kept on stressing that he thought they had a compelling, I think at one point he said a compelling case on the merits. At another point, he characterized the issue as a novel issue, and on that basis, he thought percolation was appropriate. What do you think about his telling the court on this law, this well-developed law, that the issue was novel? Is that the adjective you would have used?
I don't remember him saying novel, but it's not the adjective I would have used. And it's clear. I think even Justice Gorsuch tipped off that he thought this was a bad argument on the merits. I don't think that there are going to be anything close to 5 votes for the government's position. Um, and so I didn't think anything he said about the merits was prudent in terms of, you know, acting wisely in the oral argument. And I don't know if that's just his style and because he was like a bulldog, almost like a kind of law student's first oral argument and not wanting to concede something, which is sometimes important, but you don't have to make the point 18 times in the oral argument. And it was almost disrespectful the way he was kind of not going along with the hypothetical, I thought. So I didn't think any of that was effective. And again, I just assume that it was for a different audience in the White House.
So maybe let me ask you this last question. It relates again to the merits. I know the court is concerned about universal injunctions, but you pointed out all the ways that we could wind up with a long period of irresolution on this issue. And what most people in the country are concerned about is not this obviously important procedural issue. They're concerned about the clarification here that the law stands as everybody understood it, and that birthright citizenship is not going to be altered by this executive order. The right to birthright citizenship is not going to be altered by this executive order. Why shouldn't the court and counsel on the other side from the government certainly volunteer this? Why shouldn't the court go ahead, request supplemental briefing, proceed to the merits, and leave this universal injunction set of issues to another day?
Well, that issue, it could do that. This is this is a bizarre, an unusual context. The court has not granted certiorari in this case. The court is simply responding to an emergency application by the government to basically stay a lower court stay a lower court proceeding um, that had enjoined the government from issuing this executive order. So it's not even on the merits. The merits are technically not even presented. The issue that's presented is the universal injunction issue. I do think the court, it's easy to imagine that the court issues an opinion that deals with universal injunctions and also at the same time grants certiorari and deals with this issue expeditiously, possibly even enjoining the government from it, the court enjoining the government from issuing the birthright citizenship order. And that raises an interesting question whether an injunction by the Supreme Court of, as opposed to a lower court of government action, is that a precedent that the government will respect universally? I mean, that's a kind of an interesting issue. But look, I think that the court will address, if not here in this case now, I think it will address the birthright citizenship question soon.
Okay, so my last question, and there's so much to discuss here, but and maybe I'm wrong about this. I thought there was a certain irony to Sauer conceding the point of judicial supremacy that you rightly put so much emphasis on, at the same time as that he was telling the court that this administration wasn't going to pay any attention to what appears to be settled precedent, decades of executive practice, congressional authorization that seems to have clearly settled the constitutional issue that the executive order is now trying to sort of reverse and put into a completely different direction. Does that strike you as maybe overstating that there's an ironic quality to that? They respect judicial supremacy, except in this case, they're prepared to pretend that the court hasn't spoken on the issue?
So I'll address that, and then I'll address a larger point. Yes and no. I mean, yes, there's an irony to that, but it's not the first time. You know, administrations are allowed to challenge old precedents. Administrations, Democrat and Republican, who believe that an old precedent is no longer valid, can bring challenges to those precedents and ask the court to overturn those precedents. We don't really know if that's what the court, how they're going to. I mean, I haven't read the merits briefing in the Ninth Circuit. I don't really know whether that's what the government's going to ask the court to do. But let me make a broader point, and I addressed this in the piece, and this resulted from a conversation you and I had, and that is a related point, which is, well, why should the court trust Sauer's pledges? I mean, I suggested in the piece that the government would, excuse me, that the court would likely rely on this concession about judicial supremacy because it's to the court's advantage and because it addresses a lot of concerns in the air about whether the Trump administration is going to respect Supreme Court judgments and precedents. So the question arises, should they trust Sauer? Is Sauer trustworthy? Is the administration trustworthy? And the answer to that question is probably not. I mean, who knows is the right answer. Sauer may well mean what he says, but he might have to change his mind tomorrow or next week or next month. And who knows if the White House changes its mind and sends down a lightning bolt command to the Justice Department, which the department has made very clear it will listen to. So this throws, a large monkey wrench into the importance of this point, because the point about the court being able to resolve illegality on a universal basis, government illegality on a universal basis, really does depend on the government complying with judicial precedent. And whether Sauer and the Trump administration can be trusted on this point is an entirely open question, it seems to me. I say in the piece that this definitely raises the stakes for noncompliance later. It puts a lot of people in the Solicitor General's office's personal reputations on the line publicly and with regard to the court and the Justice Department more generally. So I do think this is a very important concession with real world implications. I do think the government will take advantage of it in its opinion. But whether the Trump administration abides by this pledge, it's far from clear. And even if they don't abide by the pledge, will they play games with it? Will they play games with the Supreme Court judgment? Will they threaten not to comply like they have in other contexts? There's no way to know, and therefore one must take the Sauer concession with at least some grain of salt.
Well, this has really been interesting, and I think the posting makes a critically important point. So thank you, Jack.
Thank you very much, Bob.